Now we do have some criminal questions that came in. We got one that says, "What are your thoughts on to blow or not to blow if you're pulled over or suspected of a DUI and you ask to blow? What do you do?" And Mike here is the man on that subject.
Well, I will tell you this: DUIs. What most people don't realize is there's two different aspects to a DUI. There's the administrative aspect and the criminal aspect. So when you get pulled over for a DUI, if you're arrested for a DUI, you're going to lose your license whether you blow or don't blow. The amount of time that you lose your license for will be affected by whether or not you choose to blow or not. There's a lot of different intricacies in terms of whether you have a hearing or not, but what I can tell you is if you don't blow, it is going to be a more strict period of time where you don't have a license. The second time you don't blow, it's a separate criminal offense. But on the flip side to all of that, the more evidence that the law enforcement officer has, then the harder it is to defend the criminal case. So it's difficult because some people say, "Hey, my driver's license is everything, and if I lose it, I can't work, I can't pick up my kids, I can't do all that." But obviously, if it's something where you know you have you believe you've had too much to drink and you blow, an otherwise defendable case may be very difficult now to defend because now you've got this high blow that you have to contend with in court. Um, so that everybody understands, when you sign your driver's license, you are giving implied consent that you're going to blow. So all the penalties that stem from not blowing are the fact that you've now revoked that consent and say, "Hey, I don't want to blow any longer." So it really depends. From a criminal aspect, less is more. So the less you say, the less information that law enforcement has, then obviously the harder it is for the state to prove a case against you. So from that aspect alone, then obviously the do anything and just say, "Hey, I want an attorney present. I don't want to answer any questions without an attorney present," and go from that point. Um, but there's a lot of things that go into that decision. In other words, if you've had a DUI before, if you've refused before, now it's a separate criminal offense. So now maybe the DUI is defendable. But now it's easy for them to show, "Hey, you didn't blow." Um, the penalties increase with respect to a refusal to blow. So it's a hard question to answer. I think from a purely criminal standpoint, less is more. So the less you do, the less information you give. Uh, Field sobriety exercises, providing a breath sample, that's better to defend a criminal case if you don't provide those things. And you can be very courteous and say, "Hey, look, I'm not gonna do anything. I don't want to do anything without an attorney present." And they're going to have to make their decision based on what they've seen so far. So the less that they've seen, then the better it is to defend. But again, it is going to mean harsher penalties for your license, which means it could be harder to then get your license back. It could be longer times where you have what's called hard time restrictions, where you can't drive at all. So it really depends on what's most important to you. But from a purely criminal standpoint, less is more.